Right now, across Florida, slip and fall victims are settling for a fraction of what they're owed. Not because their injuries aren't real, because they don't know what actually drives the number. The adjuster handling your claim knows exactly how each factor weighs. You need to know too. I'm Doug Burnetti, founder of Burnetti PA here in Florida. I've spent over 35 years handling premises liability and slip and fall cases, and what I'm about to share is what I walk every client through before we ever touch a settlement offer. By the end of this video, you'll understand the specific legal factors that push a slip and fall case value up in Florida and the tactics adjusters use to push it back down. And here's what changes when you finish watching. When someone puts a number in front of you, you'll know exactly whether it reflects what your case is actually worth. Let's get into it. The damages that build your starting number. Florida premises liability law measures your loss in two categories: economic damages and non-economic damages. Economic damages are the concrete documented costs, medical bills, lost wages, and any future treatment your doctor has projected in writing. Under Florida law, every dollar of economic loss is potentially recoverable, but only if it's documented. Let me give you a real-world example. I once had a client who tore her meniscus in a grocery store fall. By the time she came to me, the chain's adjuster had already been in contact. She had $42,000 in verified medical costs, $18,000 in documented lost wages, and an $11,000 physical therapy projection her doctor had signed. The adjuster's opening offer was $25,000. She thought she was doing something wrong. She wasn't. The adjuster wasn't confused about her injuries. He knew she couldn't produce a receipt for every treatment dollar, and that claimant who can't document every line item will negotiate away every undocumented dollar. We produced the paper. The gap closed. That's not a legal problem. That's a documentation problem. The claims processor reviews every record for what isn't there. Every gap in your treatment timeline becomes an argument that your injury isn't as serious as you claim. When you see your doctor, keep every invoice, every explanation of benefits, every note about your treatment plan. A gap in your records is a gap the adjuster will use against you. The fault rule that can zero out your entire recovery. In 2023, Florida passed House Bill 837, and it changed the math on slip and fall cases in a way that most injured people have no idea. Under Florida's new modified comparative negligence standard, if a jury determines that you were more than 50% at fault for your own fall, you recover nothing, not a reduced amount, zero. Think about this situation. A woman walks into a restaurant, no wet floor sign anywhere in sight, and goes down a slick tile floor. She calls me a few weeks later. By then, the adjuster's investigator has already pulled surveillance and interviewed the staff. They built a file showing she'd been looking at her phone at the moment she fell. The adjuster assigned her 55% at fault. Under the new standard, that wiped out her entire recovery. Her $80,000 in damages went to zero. The case settled for $12,000. She had never heard of modified comparative negligence before she walked into my office. And by the time I explained it, there wasn't enough left in the case to fight with. The insurance company's field adjuster starts documenting every possible contributing factor to your fall from the moment that the incident report is filed. Every statement you give, every social media post, every prior injury, anywhere in your medical history goes into that file. Before you give any recorded statement to anyone from the property owner's side, understand this. The purpose of that call is to build a comparative fault case against you, what the property owner knew and when they knew it. Under Florida Statute 768.0755, a business can only be liable for a dangerous condition on their property if they had actual or constructive knowledge of it and failed to act. That word knowledge is where most slip and fall cases in Florida are won or lost. Constructive knowledge means the condition existed long enough that the business should have caught it during a reasonable inspection. Florida courts look at the substance itself for evidence of how long it had been there. Here's another example. An older man is walking down the main aisle of a big box retail store and goes down a spill. The substance that was spilled on the floor was dried at the edges and discolored underneath him. The texture told us the spill had been sitting there for hours. We subpoenaed the cleaning logs and found the last documented inspection was 4 hours before the fall. Those logs became the spine of his case. And here's what I want you to understand. The store's legal team knew those logs existed from day one. They were counting on him not knowing to ask for them. The property manager files an incident report the day of your fall. At the same time, the company's claims department gets notified. The cleaning logs get preserved in a format the company controls and that you can't access without a subpoena. Request the surveillance footage, the cleaning and inspection logs, and the full incident report in writing within 72 hours of your fall. That surveillance footage is on a recording loop. Once it cycles over, it is gone for good. Non-economic damages and what moves the multiplier. Economic damages set the floor of your slip and fall case value. Non-economic damages include pain and suffering, loss of enjoyment of life, mental anguish, mental pain and suffering, and these things have real value, especially in a serious injury case. Florida does not cap non-economic damages in most personal injury cases. That means the number is subjective, and both sides fight hard over that number. Insurance companies use a multiplier method internally, typically between 1.5 and 5 times your economic damages. And they always start at the lowest number they can justify. I've had clients with nearly identical medical bills on completely opposite ends of that range. One had consistent treatment records, a written statement from her husband and how her life had changed, and a note from her doctor about how long-term activity restrictions had been affected. The other had a 3-month gap in treatment and nothing on paper about daily impact. The first case settled for $112,000, the second case for $41,000. Same category of injury. The documentation is what separated those two numbers. The adjuster scores every non-economic factor against an internal formula. Documented treatment gaps push that multiplier down by default. Keep a pain journal starting the day of your injury. Have someone close to you write a statement about what they've seen change in your daily life. What isn't documented doesn't get paid. The deadline that now controls everything. Florida statute of limitations for slip and fall cases used to be 4 years. In March of 2023, House Bill 837 cut that window in half. You now have 2 years from the date of your fall to file a lawsuit in Florida. Miss that deadline by 1 day and your case is permanently barred. No exception for not knowing about it. No exception for still being in active treatment. The clock starts the day you fell, not the day your doctor released you. The most actionable thing you can do right now is write down today's date and your injury date. If those 2 dates are less than 2 years apart, you still have time. If you're within 6 months of that 2-year mark, call a Florida premises liability attorney today, not next week. Evidence in a slip and fall case degrades faster than in almost any other personal injury case. Surveillance footage gets overwritten in 30 to 90 days, sometimes sooner. Employees who witnessed the fall change jobs. Cleaning logs get archived in formats that require active litigation to unlock. The sooner your attorney sends a formal preservation demand, the more of that evidence survives. Your case value is only as strong as the evidence that supports it, and that evidence has an expiration date that you cannot extend. Knowing the value factors in your case matters. But that value disappears if the evidence proving what the property owner knew gets destroyed before anyone preserves it. Every day without a formal demand is a day that footage cycles over and witnesses move on. Watch how much does it cost to hire a truck accident lawyer in Florida right now. See you over there.